Hi, everyone, and welcome to the Animal Law Symposium, Protecting Animals Through Transparency, Engagement, and Regulatory Practice. I'm Brittany Peet, Director of the Animal Legal Defense Fund's Transparency and Regulatory Affairs Program, ALDF's newest program, which kicked off its work just 6 months ago. Our focus is regulatory advocacy, transparency through data gathering and analysis, and expert engagement. So our 2026 symposium includes 4 virtual panels examining how these areas can help legal professionals advance animal protection. A few housekeeping items before we get started. All sessions feature closed captioned subtitles. To enable this feature, click the upward arrow near the CC button at the bottom of your screen and select Show Subtitles. Please enter any questions you have into the Q&A box that you'll see at the bottom of your screen. We'll get to as many of those questions as we can. The symposium is being recorded, and the recording will be shared with you later via email. Now, please take a moment to answer the poll question on your screen. If you're seeking continuing legal education credits for this session, please click yes. Attorneys seeking credit will receive information via email after the symposium concludes. Okay, thank you. Now on to our session. Our first panel today is a deep dive on how 3 recent opinions from the U.S. Supreme Court are reshaping the regulatory landscape and their potential impacts on legal advocacy for animals. Each of our panelists will first introduce us to one of these cases, and then we'll transition to a roundtable discussion. And I'm just going to include very brief descriptions of our panelists, so please make sure to check out their full bios on the symposium website. This is going to be a fascinating panel, and there is so much to talk about, so let's get into it. And remember to add your questions to the Q&A. Our first panelist, Delciana Winders, is an associate professor of law and the director of the Animal Law and Policy Institute at the Vermont Law and Graduate School. Delcy, please introduce us to SEC versus Jarkissi.
With pleasure. Hi, everybody. Thank you for being here. Thank you, Brittany and ALDF, for having me. When the U.S. Department of Agriculture documented Animal Welfare Act noncompliances that resulted in the deaths of 3 primates at Oregon Health and Sciences University, OHSU, the largest of 7 taxpayer-funded national primate research centers, it entered into a settlement agreement with OHSU. And OHSU paid $12,000 to resolve those violations. It's a paltry amount, especially for a research facility with a massive budget, and especially when you consider that the USDA could have assessed $130,000 in fines. Then, the USDA subsequently documented 7 more primate deaths at OHSU. And that time, it didn't assess any penalty. It issued a warning to OHSU. A little over a year after that warning, another primate death, another warning. Another 6 primates died. The USDA did require OHSU to pay a fine. It was a little higher than the first one. This time they paid 12% of the potential fine they faced, so 12 cents on the dollar. Undeterred, less than a year later, another violation, another death, this time of a 2-day-old macaque. And the USDA issued a warning. So if you're not counting, that's 18 primate deaths, 2 heavily reduced fines, and 3 warnings. Last year, yet another negligent primate death and a 4th warning. I have closely monitored Animal Welfare Act enforcement for well over a decade now, and the agency has long relied too heavily on warnings, but not at the level that we're seeing now. Until recently, I had never before seen a facility receive a 4th warning. Now, facility after facility is receiving warning after warning, and these are for serious citations. According to the enforcement data that the USDA is legally required to post, the last time a research facility paid any amount of money for Animal Welfare Act citations was in the summer of 2024. Since then, the agency has issued 73 warnings just to research facilities. So, what's going on? The other thing that happened in summer 2024, besides the last fine of a research facility, is that the Supreme Court held in Securities Exchange Commission, SEC versus Jarkissi, that the SEC could not fine someone for fraud without first giving them a jury trial. And this should not have anything to do with animals, yet it is very much affecting animals. So I'm going to tell you a little bit about that Supreme Court decision. It's a little bit complex, so please bear with me, and then we'll come back to the relevance of it for animals. So, George Jarkissi, he's an amateur blues musician, and he owns Patriot 28 LLC, under which he had two hedge funds. In his capacity as hedge fund manager, he did some things you're not supposed to do. He lied to his investors about a bunch of things. He charged them excessive fees. He committed securities fraud. And so the SEC initiated a proceeding against him. It was a quasi-judicial administrative proceeding, the type of proceeding that administrative agencies hold every single day to enforce a vast array of laws. And ultimately, Jarkissi was ordered to pay a $300,000 fine, significantly more than we see in the animal welfare context. He appealed, and one of his arguments was that he was entitled to a jury trial before he could be assessed these fines. And the Supreme Court agreed with him. It said, yeah, the Seventh Amendment requires a jury trial. You probably know, maybe, that the Sixth Amendment provides that in criminal proceedings where your liberty is on the line, you are always entitled to a jury trial. The Seventh Amendment addresses the jury trial right in the civil context, and it's far less absolute. It says it only applies to common law cases on its face. The SEC's case against Jarkissi, of course, was not a common law case. It was brought under the Securities Exchange Act and other statutes. But the Supreme Court has held that the jury trial right also attaches to statutory claims if, as they put it, quote, a cause of action resembles common law causes of action. So basically here they said the statutory securities fraud is parallel to common law fraud, and therefore we're going to treat it like a common law claim for purposes of the Seventh Amendment jury trial right. That is not the end of the analysis, though. Very importantly, there is what is called the public rights exception to that jury trial right. So even if you meet that common law analog test, there's still this exception. And so it's only cases involving what are called private rights where there is a jury trial right. And the key to determining whether something is a private right, the Supreme Court has told us, is whether it is, quote, made of the stuff of the traditional actions at common law tried at the courts at Westminster in 1789. But if something was not in that bucket, it could fall within the public rights exception. And the Supreme Court reiterated in its Jarkissi decision that when Congress creates new statutory public rights, it can assign their enforcement to administrative agency without running afoul of the Seventh Amendment. And the Supreme Court has previously held that this applies in a wide range of contexts. It includes immigration, might be politically motivated, veterans benefits, revenue collection, the Occupational Safety and Health Act, and more. In Jarkissi's case, the court said the exception did not apply, but it was very careful not to overrule the exception. So let's talk about the exception in the context of animal law. So in the wake of the Jarkissi decision, the USDA indicated that it was awaiting guidance from the Department of Justice about the scope of Jarkissi and that it was not assessing Animal Welfare Act fines in the interim. It's now been almost 2 years since the Jarkissi decision, and we're not seeing fines still. I gave the example of research facilities, but those are just one of the various types of entities regulated under the Animal Welfare Act. You also have zoos, circuses, breeders, puppy mills, etc. But the important difference is that even if the USDA isn't exercising its ability to assess fines against these other types of entities, it still has other enforcement mechanisms available, and it is using those in some cases. So it can, for example, suspend licenses, it can revoke licenses. It cannot do those things for research facilities. Fines are effectively the only enforcement mechanism when it comes to research facilities. And so I cannot emphasize enough that means by not assessing fines, the USDA is giving research facilities carte blanche to violate the Animal Welfare Act. It also matters for other types of entities because it removes an important enforcement tool, which also provides leverage. So it's an issue across the board. Um, is the USDA's not assessing fines defensible? I contend that it is not. And I would point you to the Supreme Court's decision in Atlas Roofing versus OSH Review Commission, which the Advocacy Court expressly declined to overrule. And that case involved the Occupational Safety and Health Act, where the court said this requires employers to comply with regulatory safety and health standards, standards that brought, quote, no common law soil with them. That, of course, is true for the Animal Welfare Act as well, and animal protection laws more broadly. There certainly were no common law claims involving animal protection at Westminster in 1789. Really, animal protection claims are, I would say, consummate public rights, even the apotheosis of public rights. And you don't have to take my word for it. A federal court has addressed this question in the context of the Horse Protection Act and said, unlike securities fraud, the Horse Protection Act doesn't replicate a common law claim, therefore, no jury trial right. The court noted that we didn't have any animal protection laws in the US until the 19th century, long after 1789. And therefore, it said Congress can withdraw that from the courts and let agencies handle it. And the court reached this based on the USDA's own briefing. So less than 6 weeks after the Jarczy decision, the DOJ, the Department of Justice, on behalf of the USDA, told the court that, quote, USDA adjudications under the Horse Protection Act involve public rights. That note about no animal protection laws until the 19th century, that came straight out of the USDA's brief. In the Court of Appeals, it unequivocally said, this doesn't resemble any common law rights. The public rights exception applies. Just last month, it filed another brief reiterating this. In addition, in briefing another case, an Animal Welfare Act case, the USDA asserted, again unequivocally, that there were no roots in common law because the primary purpose of the Animal Welfare Act is animal welfare, and there were no claims at 1789, public rights exception applies. And there too, the judge, in that case, an administrative law judge, agreed with the USDA and ruled that, like the Horse Protection Act, the Animal Welfare Act, quote, clearly involves statutory public rights. So where does this leave us? Since the Jarczy decision, the USDA and the Department of Justice have consistently taken the position publicly that the Horse Protection Act and the Animal Welfare Act fall within the public rights exception, which I think is right. And therefore, there's no jury trial right. And multiple decisions have affirmed that interpretation. And yet, nearly 2 years after Jarczy, the USDA is not exercising its authority to assess fines, and many animals are suffering as a result. Thanks.
Thanks so much, Delcy. Our next panelist is Nick Fromhers, an independent consultant and adjunct professor at Lewis and Clark Law School, where he teaches in the areas of administrative law and comparative environmental law. Nick, please tell us about Corner Post Inc. versus Board of Governors of the Federal Reserve System.
Well, first off, thanks so much for having me today and for everyone in attendance. I'm going to talk about the Corner Post case, 2024 Supreme Court decision, came down within 3 days, I think, of the case we'll hear about next, Loper Bright. And the Corner Post decision altered the way courts analyze the statute of limitations pertaining to at least some lawsuits challenging agency actions. And here we're mainly, asterisk always, right, but mainly talking about challenges of regulations. Now, the basic headline coming out of this case in the popular press and in, uh, academic circles and by legal analysts is that, there's this new opportunity for plaintiffs to challenge regulations that have been around for a long time. Regulations that, at least to some extent, have become part of the regulatory woodwork, have perhaps or even probably survived challenges in the past, like shortly after they were promulgated. And that, agencies may have thought, and I suppose you might say, regulated entities as well, and others may have thought were immune effectively from certain classes of challenges thanks to the statute of limitations. And I'm going to go through the facts a little bit here in a second, but the Supreme Court in Conner Post, basically said, in essence, actually, a given plaintiff under the right circumstances can bring a facial challenge to an even decades-old regulation. And to the extent that the general 6-year statute of limitations is applicable, that's under 28 U.S.C. Section 2401, that statute of limitations won't bar that suit, right? Even though, looking at math from a more, say, normal or traditional perspective, you would say, hey, that's way out of time. So the immediate reaction was, holy smokes, Chevron's dead. Of course, got the Seventh Amendment situation that Delcy just discussed. And now on top of all that, the Supreme Court green lights a whole new class of claims that the lower courts had pretty much universally held were time barred. We're going to see this tsunami of lawsuits challenging old regulations. And of course, if even a fraction of these kind of corner post-like suits prevail, then that's going to have a deregulatory effect. And maybe that's great for industry to generalize, but not so great for animals and the environment. I should say I'm a little bit more in the environmental lane in a lot of my work, so I apologize if I use some examples from that sphere. We'll circle back to the consequences in a minute. Has that, I don't want to say prediction, but that initial reaction played out or not? But digging a little bit deeper into the facts or setting up the facts, the basic story of Corner Post goes something like this. A roadside truck stop, gas station, and convenience store, kind of one of those combos, incorporates in 2017 and opens for business in 2018. And pretty much right away, the business, called Corner Post, gets annoyed by the, quote, interchange fees. What are those? Those are the fees that the merchant, in this case Corner Post, has to pay to Visa, MasterCard, etc., every time someone uses a debit or credit card for a purchase, which, as we know, is more often than not. Now, the amounts that Visa and MasterCard are in turn allowed to charge, right? How much is that interchange fee? That's subject to a regulation issued by the Federal Reserve Board. So that's our agency here, is the Federal Reserve Board. That regulation is in turn, of course, grounded in statute. So, and I apologize for jumping back and forth in the timeline, but it's a statute of limitations case. So the statutory text comes from 2010. It's the Durbin Amendment to the Dodd-Frank Law. And the particular provision from the 2010 law tasked the Federal Reserve Board with making sure that interchange fees were, quote, reasonable and proportional to the cost incurred by the issuer with respect to the transaction. The issuer in this case being your Visa and your MasterCard, right? So, all right, the regulation then comes down a year later in 2011, and the Federal Reserve Board sets a maximum interchange fee of 21 cents per transaction plus 0.05% of the transaction's value, right? So that's kind of, hey, Visa and MasterCard, you can't charge more than this. And of course, they're going to charge all of that, right? So fast forward to 2018, okay? 7 years after the regulation, and Corner Post has just opened for business. And it is effectively subject to these fees, even though it's not a directly regulated entity, right? Visa and MasterCard are the regulatory targets. But it feels the effects, right? It's worried about customers complaining, losing customers, etc. So 3 years later, so from 2018, 3 years later in 2021, Corner Post sues, alleging that the regulation is unlawful because, hey, it's not in fact reasonable and proportional as required by the statute. So if we kind of do our math here, the suit comes 10 years or so after the regulation was promulgated. Well, what's the relevant statute of limitations? That comes from Section 2401 of Title 28 of the USC. And that's the general statute of limitations applicable to civil suits against the US government. So many suits under the APA, if there's not a specific statutory review provision with its own statute of limitations, and there are in many cases, lots of environmental acts, for example, Clean Air Act, Clean Water Act have those. But if that's not applicable, and there's a lot that don't have that, then Section 2401 comes in. And it says, and I'm going to read the text just because, this is one of those Supreme Court's very much, writing 20 pages about a sentence. Every civil action commenced against the United States shall be barred unless the complaint is filed within 6 years after the right of action first accrues. 6 years. Okay. So you might think, well, this suit is clearly time barred. The regulation was issued in 2011. And here Corner Post is trying to bring a facial challenge, right? It's claiming this is ultra vires, right? 10 years later, right? And that's what the lower court held. Like almost all lower courts, the Eighth Circuit held that when plaintiffs bring a facial challenge to a final agency action, the right of action accrues, that clock begins to tick, and the limitation period begins to run upon publication of the regulation. So Corner Post, you're out of luck according to the Eighth Circuit and almost every other court at the time. Supreme Court disagrees. Supreme Court parses the language and holds that and here I'm going to quote again, an APA plaintiff does not have a complete and present cause of action until she suffers an injury from final agency action. So the statute of limitations does not begin to run until she is injured. On its face, that sounds reasonable. But applied to Corner Post, well, that injury didn't occur until they opened for business, 2017, 2018, depending on how you measure it, and they began to feel the effect of the regulation. So under this new rule, Corner Post gets to proceed, whereas under the old rule, hey, begins to start upon publication, Corner Post is out of luck, right? So that's the case in a nutshell. Now to circle back and I hope I'm not abusing my time here, but to wrap things up for now and just to plant a couple of seeds, I think we should revisit the notion or the question, really. I think it's still a question that Corner Post, portends kind of opening the floodgates for a new class of anti-regulatory lawsuits. On one hand, that's clearly true. I mean, it clearly does, green light lawsuits that were previously time barred, right? On the other hand, a tsunami might not be what we're looking at. So just as a fun little exercise for myself, now I'm going to foist it upon you. I looked this morning on Westlaw. It's a crude proxy, but it's something, to look at cases citing Loper Bright versus citing Corner Post. And we've got 3,000 cases citing Loper Bright, according to Westlaw as of this morning, versus 208 citing Corner Post. Very, very crude proxy, doesn't necessarily reflect, impact, right? Impact can be felt in other ways besides, a court citing a decision, of course, but something to think about. And I do think that there are some reasons to think, why corner post, although it's, deregulatory in effect, may not be that big tsunami that initially some folks envisioned. One of those being that, many suits, as I mentioned, challenging agency action are subject to different program-specific statute of limitations. So, most of the pollution control statutes, federal pollution control statutes, have their own statute of limitations. And so corner post doesn't, directly at least affect those or kind of open up, challenges that weren't existent. On the other hand, I don't want to downplay the impact, especially when you combine it with, advocacy and Loper Bright and other cases we'll probably discuss, because there are certainly examples of suits that are absolutely the offspring of corner post. One is a Texas versus Nuclear Regulatory Commission lawsuit, where a group of states and companies are seeking to invalidate a 1956 rule. Promulgated, in fact, by the agency's predecessor, the Atomic Energy Commission. That obviously under the old rule would have been, time barred over half a century ago. The last thing I want to say, just to end now and to get folks thinking, I guess, is that this is probably a case where, it's not all bad news for animal and environmental advocates. And I'm going to kind of lump those together if that's okay. Although deregulation or deregulatory opportunities is, from my perspective at least, kind of a net negative, I'm going to say. There are plenty of regulations, old and new, that are not exactly friendly to animal welfare, to the environment, etc. And I was just reading a case that came down early this year, Oregon Wild versus the United States Forest Service, where thanks to Corner Post, Oregon Wild, an environmental NGO, is able to sue and challenge a 1992 categorical exclusion under NEPA, made subject to notice and comment, allowing prescribed burns and commercial timber sales. And again, previously that would have been time barred. So it's one of those, both kind of sides, if you will, will get a bite at that apple. I still don't feel great about the decision overall, but that's what I'd like to say for now. So thank you.
Great, thanks, Nick. And our next panelist is Kristen Monsell, Ocean Programs Litigation Director at the Center for Biological Diversity. Kristen works with the center's Oceans program to protect marine species and their habitat. Kristen, let's hear about Loper Bright Enterprises versus Raimondo.
Thanks, and echoing the thanks for having me, and thanks to everyone for attending this panel. So Loper Bright was another decision issued in 2024. The court was busy issuing horrible decisions that year. And it was a 6-3 decision along the usual ideological lines. And Chief Justice Roberts wrote the decision for the majority. And the case stemmed from a fisheries issue, and specifically whether the National Marine Fisheries Service could require fishermen to pay for observers on board on their vessels to track bycatch, which is when fisheries accidentally capture, entangle, or kill non-target species like other fish that they're not trying to catch, dolphins, turtles, seabirds, etc. And the case dealt specifically with the meaning of the word carry in the Magnuson-Stevens Fisheries Conservation Management Act. It's quite the mouthful, which is the statute that governs the authorization and management of commercial fishing. And there was a provision in the statute that required fishers to carry observers on board their vessels. And I think the petitioners did a good job of picking the right case because it enabled them to sort of characterize the case as these small, local, individual fishermen, just trying to make a living while the man is trying to take away their rights. And it's just this, overreach of the administrative state. But the case was actually funded by the Koch brothers and other super conservative entities specifically to get the decision that the court ultimately issued, which was to overturn a case that was issued in the 1980s called Chevron versus the Natural Resources Defense Council. And that was a case where the Supreme Court developed a doctrine for how to interpret federal statutes, and specifically for when an agency is interpreting a statute it administers to take an action under that statute. So, for example, it would be the framework the court applies when the National Marine Fisheries Service is issuing regulations under Magnuson or under the Marine Mammal Protection Act, or when APHIS is acting under the Animal Welfare Act. And the doctrine consists of two steps, which became known as the Chevron two-step, which sort of was in place for 40 years, from June 1984 to when the decision issued to June 2024, coincidentally, when Loper Bright issued. And that two-step inquiry provided the standard framework for judicial review of federal agencies interpreting the statutes they administer. And under the framework, the court would first ask if the statute is ambiguous, using all of the traditional tools of statutory construction to answer that question. And if the answer was no, then the court would apply the plain meaning of the statute and reject any agency interpretation or agency action inconsistent with that plain meaning. But if the answer was yes, and the statute was ambiguous or silent on the particular issue, then the court had to determine if the agency's interpretation was reasonable and defer to that interpretation if it was reasonable. So what this meant was, like, even if there were multiple possible interpretations of a particular law, and the court would have interpreted the law differently, the court had to defer to the agency's permissible interpretation. And the decision, which actually upheld a Reagan-era EPA interpretation of the Clean Air Act to ease regulation of emissions, was actually hailed by conservatives at the time because it was seen as a way to sort of promote a deregulatory agenda, but then ultimately became sort of the opposite. It became a target for those seeking to curtail the administrative state, which eventually led to the Loper Bright decision, which expressly overrules Chevron and the entire framework that sort of governed the administrative law space for decades. And it did so upon looking at many things, including the Chevron framework itself and its instruction that courts must defer to agencies' interpretations, even where they think another interpretation is better, and found that that's inconsistent with the Administrative Procedure Act, which specifically tells courts, not agencies, to decide relevant questions of law. And even in the context of when those laws are ambiguous, and instructs that courts have to set aside agency actions when a court finds them unlawful. So where does that leave us? The court said that now, when interpreting a statute, agencies don't get any deference, and instead the court must now interpret those laws in accordance with the best reading of the statute. And Roberts specifically said, quote, agencies' interpretations of statutes, like agencies' interpretations of the Constitution, are not entitled to deference. Rather, under the APA, it remains the responsibility of the court to decide whether the law means what the agencies say. And one court in one of our cases recently noted that, sort of summed it up as how SCOTUS held that courts can't defer to agencies' interpretations of the statutes they implement, but courts have to now use their independent judgment to determine the best reading. And while it changed the court's role in statutory interpretation and regulatory analysis, what it didn't change is the agency's role, which has always been to adopt the best possible interpretation of the statute. And while the decision overruled Chevron, it also didn't wholly reject agency expertise or authority. And it specifically makes clear that in some cases, a statute's meaning is that the agency is authorized to exercise a degree of discretion, and that in some situations, the role of the courts is to recognize those constitutional delegations, fix the boundaries of the delegated authority, and ensure the agency has engaged in reasoned decision-making within those boundaries. It also recognized that courts still must afford agencies a substantial degree of deference when they're engaging in policy making or fact finding, pointing to 7062 of the Administrative Procedure Act and its arbitrary and capricious standard of review. That said, the decision is sort of widely seen as shifting power away from federal agencies and to federal courts and judges. And there's lots of questions that are still unanswered in terms of exactly what it means. I think one advantage for the work that I focus on, which is a lot of work under the Endangered Species Act and Marine Mammal Protection Act, is that those laws are first and foremost about protecting animals and about protecting the habitats that they need to survive. So they're very strong laws in that regard. So the best meaning of a particular provision within those statutes or a particular phrase within those statutes should be construed in accordance with that protective purpose. Of course, super conservative judges aren't always going to follow that, but that's one thing that when everyone sort of characterized the decision as the sky is falling, sort of gave me hope that that wouldn't be the case. And Chevron deference has always been a double-edged sword for us, and because of the degree of deference that agencies get under that second step of the analysis, we've tried to focus our arguments on Chevron step one, which is essentially what Loper Bright says now. You just look at what the best meaning of the statute is in accordance with all of the traditional tools of statutory interpretation. I mean, that said, industry is definitely going to be using it as well to try and push their own interpretations of various laws. And I think, big picture, one thing it certainly hasn't changed for us is that we'll keep on suing agencies to hold them accountable and help protect imperiled species and the places they need to survive. So that's it for now. Thanks.
Heck yeah. Thank you, Kristen. All right, let's get into the discussion. Please remember to drop any questions you have into the Q&A. My first question is going to be for everyone. How might advocacy groups on both sides of regulatory debates change their litigation or regulatory strategies based on these opinions? Delcy, would you care to start?
Yeah, I think I'm not going to talk about jargony on this one. I think the combination of Loper Bright and Corner Post opens up some really interesting opportunities that are, as Nick and Kristen have said, double-edged swords. But I think there are some regs that have been on the books for a long time that animal advocates don't think are consistent with the statute. I could give some specific examples. I'm not going to weigh in on my thoughts on the merits of those arguments. But I think, advocates should be scouring the regulations and identifying opportunities to challenge them in light of this new terrain.
Indeed. Nick, any thoughts from you?
Yeah, I mean, I would definitely echo all that. I think that the, you know, the extent to which Loper Bright, in particular, focusing on that case, sort of diminishes, as Kristen said, it does away with Chevron deference, right? Chevron is gone. So agency power overall to kind of shape policy through regulations, et cetera, is diminished. And, that shift kind of goes to the courts. But, on the other hand, Loper Bright said, hey, we've still got other forms of deference or at least respect, right? We've got Skidmore, and Skidmore is kind of, I used to always kind of make fun of it in my admin law class, and now I'm like, maybe I should not be so dismissive. But Skidmore basically says, hey, you know, uh, even if lacking the power to control, agency interpretations can have persuasive power, and that persuasive power, of course, depends upon the thoroughness, how long-standing it is, the extent to which it kind of is in the bailiwick of the agency's expertise, et cetera. So I think just strategically thinking about agencies looking to defend rules that they'll probably, or at least they would be smart to, I think, try to invest more in building records, thinking about Skidmore. In theory, they've been doing that all along, right? But I think to the extent that agencies want their regulations to withstand challenge, they'll weigh in even more deeply into building a strong record that resonates with Skidmore.
Great, Kristen.
Yeah, I would agree with both of those things as well. And one thing that we've started doing, which sort of gets at the record issue that Nick was talking about, but slightly different twist on it, is in rulemaking petitions to agencies or in comment letters, we've now started saying why what we're asking the agencies to do, or what we want the agencies to do, is consistent with the best reading or best meaning of the statute, and here's why. And to the extent that the agency has interpreted the statute previously in accordance with what we're saying, we cite that as well. And I think the agencies have started to do that to some extent too. Like, one thing that I've been noticing is that the Federal Register notices now, in some instances, have longer preambles about why what the agency is doing is consistent with the statute, because they can no longer rely on the deference that they're used to. On the other hand, there are still instances where they're not explaining their decision at all, but it does seem like they're sort of following what we're doing as well to some extent.
Great. Okay, this next question is for Delcy. Delcy, buckle up. I'm so excited to set you loose on this one. What are some legal scholars getting wrong about the implications of jarcossy on regulatory schemes like the Animal Welfare Act?
So I'm going to expand your question, because I think it's not just legal scholars, it's animal lawyers and animal advocates. People are just assuming that jarcossy applies to the Animal Welfare Act, to other animal law cases, and that's doing a huge disservice to the animals. And I think it's really important that we not just assume something applies and actually scrutinize it. And if you read the jarcossy opinion and you read the other public rights cases, and now there are a bunch more lower court opinions finding the public rights exception applicable, it becomes very clear that this, if anything, is a public right. Animal protection laws are. And so I hope advocates will start pushing back on that assumption rather than restating it themselves.
Yep. Great. Okay, this next question is for Nick. If agency rules can be challenged indefinitely, how should agencies structure rulemaking records to withstand litigation decades later?
Yeah, that's a great question. I mean, I would say so. One initial thing to note, right, is that it's not as if, and the Supreme Court addressed this um, convincingly or otherwise. It's not as if, pre-corner post old regulations could never be questioned, right? Like 6+ year old regulations could never be questioned because if there's an enforcement action, for example, a defense to the enforcement action um, brought vis-a-vis a really old regulation could still allege, hey, you know, this is contrary to law, right? Or this is arbitrary and capricious, right? And that could be raised then in the context of an enforcement action. So just to clarify, it's not it's a magnified new world from the agency's perspective. It's not a whole new world from the agency's perspective. That being said, I'm sure agencies are thinking more about, okay, how do we future proof regulations? And so, probably just more explanation. Again, the more that to the extent that a lot of these challenges will sound in, hey, this is arbitrary and capricious, you know, more reasoning will almost always be better. I suppose you could end up saying things that, cut against you in the future, but generally, like more reasoning will help. It's against statutory authority. Well, usually any big regulation is going to face those challenges early on anyway. So I'm not sure that agencies are going to or need to really think about changing rulemaking strategies and rulemaking record strategies. But yeah, probably beefing up a little bit more. So we might, see longer records there. And then I guess just one last note. Sorry, it's not directly on point to the question, but I think that one reason why maybe Corner Post isn't as scary as it's kind of scary, but isn't as scary as we might think it is because again most I'm going to say important or big regulations are challenged right early on, and the kind of arguments they face, if the regulation survives the agency is going to be able to point back to that judicial decision. And of course, it might not, be binding, it might not be circuit precedent, et cetera. But judicial decisions, anywhere do carry some weight and some kind of momentum. And so, um, you know, those first couple of decisions analyzing the regulation will be important and continue to be important to later challenges, I think. Um, so that's what I'd say on that.
Great, thank you. And Kristen, we've talked about this a little bit in the discussion so far, but I'd like to expand it a little bit more. What strategies are you seeing government lawyers using to defend agency interpretation post Loper Bright, and how can advocates respond?
Yeah, so as I mentioned, there are instances where there's longer preambles where they're trying to explain why what they're doing is consistent with the best reading of the statute, and perhaps obvious, but we're seeing a shift from them trying to shove everything into that second step of the Chevron deference analysis, so that they were almost automatically do deference by the court, and instead there's explaining why they're and arguing why their reading is consistent with the best meaning of the statute. I think, as I said, there's still a lot of questions about what exactly the decision means, but there has recently been some cases where, for example, the Fifth Circuit questioned the continued relevance of Skidmore deference, even though the Supreme Court pointed to that as something that courts can continue to use and look to past agency interpretations of a statute and evaluating, what is the best meaning. The Fifth Circuit sort of said that makes no sense when you're instructed to determine what the best meaning of the statute is as the court. It'll be interesting sort of to see if agencies continue to lean into Skidmore deference, but to the extent that their prior interpretations are not what you're advocating for, that Fifth Circuit line of reasoning might come in handy in that particular case. The DC Circuit also recently questioned the continued viability of claims challenging an agency's change in position as arbitrary, where they fail to explain, their change in position, in the context of a case that dealt with the interpretation of a statute. So I think to the extent that, those claims are coming up in cases, we could see the feds, trying to use that case to argue those claims are no longer viable in Loper Bright. So I think that answers the first part of your question, but maybe not the second so much. But
great. So another question, just to throw out to the whole panel, I'd love to talk about examples of animal-related or environmental regulatory programs where we think these decisions might meaningfully change outcomes. And whoever would like to jump in.
I can go first because this issue has always been a big pet peeve of mine. So under the Marine Mammal Protection Act, the statute since its inception in 1972 has had a instruction in it that the National Marine Fisheries Service should reduce instances of serious injury and mortality of marine mammals in commercial fishing gear to insignificant levels approaching zero. And the agency for decades has had a regulation defining serious injury, which isn't defined in the statute itself, as an injury that's likely to lead to a mortality. So essentially like equating those two terms, even though they're supposed to be distinct. And that's allowed them to determine things like, a whale's left flipper got cut off by this fishing gear, but it's still alive, so it's fine. So that's not a serious injury. I mean, in what reality, would we think a human losing a limb is not a serious injury? And because of that, there's, so much suffering that whales and other marine mammals have to endure. So that's something I'm hoping to use these decisions to fight back that reg and get them to address what is clearly a serious injury, but they haven't treated it as such. And I think, again, the overall purposes of the Marine Mammal Protection Act help with that, because it's not just about conserving marine mammals at the population level, but also about protecting individual animals from harm.
Great. Dulcie, Nick, any thoughts?
I'll jump on really fast. Just you're still on mute. Unless, did you want to go, Dulcie?
You go.
Oh, okay, I'll make mine pretty quick, or try to be pretty quick. And it's just because I was doing some research yesterday to look at what cases have kind of cropped up, and specifically cases, let's say, by environmental or animal advocates, kind of using, this is a bitter and sweet, or these are all three maybe bitter and sweet kind of decisions. Well, with the exception maybe of Delsey's case, but so advocates trying to find silver linings. And I mentioned an example, but to flesh it out a little bit more, under the National Environmental Policy Act, the basic idea is, hey, look before you leap. Agencies, if they're going to, do or authorize an action which will have a major effect on the human environment, or major impact on the human environment, they're supposed to do an environmental impact statement. The statute provides that there's this kind of carve out or way to avoid that, which is through categorical exclusions. But it's on each agency, essentially, from the Forest Service to, all of them, right? To come up with their own regulations defining what their categorical exclusions are. So, something like the Forest Service might be like, well, if there's already a road, an access road, and we're going to pave it, and it's only a mile of paving or something like that, right? You might say, well, that's small potatoes enough that it shouldn't have to do this environmental review process. But there are a lot of categorical exclusions by agencies that are pretty questionable, that seem to maybe go beyond the idea of, this kind of quasi de minimis, routine, well understood, activity where we shouldn't invest these new resources. And so, you know, those categorical exclusions in many cases are pretty darn old. Some of them, a lot of them have been subject to challenges, but that's, kind of that litigation has come and gone in a lot of cases. So, a new environmental organization is formed, for example, or opens a new chapter, near a national forest and wants to challenge a categorical exclusion, which is being used to, you know, um, allow thinning under the guise of mitigating wildfire risk, for example, and maybe that's questionable, that it should fit within the categorical exclusion. Well, that regulation, not just as applied, right? Because always kind of as applied pre-corner post, you could do that, but the regulation itself on its face, right, really doesn't fit within the statutory terms of what a categorical exclusion is supposed to be. I think there's going to be a lot of opportunities there, and so I'm kind of gonna follow that one.
Great. Delcy, anything from you?
Yes. And I'm going to hold back on my very strong urge to talk about the categorical exclusion in the slaughter line speeds context, because I know the next panel is talking about that topic. So I think I talked about the implications of this in the Animal Welfare Act context. I think that's the most significant one, that and Horse Protection Act, because that's where we're seeing, or used to see, at least a little bit of administrative enforcement. But I wanted to explain a little bit why that's so important, because you might be thinking like, okay, bring the cases in court and they get their jury trial and you can still enforce the law. That is not viable for a number of reasons. One, the Department of Justice's authority to bring those cases in court is pretty limited, particularly if we're talking about research facilities. Two, their capacity is even more limited. So the division within the Department of Justice that is tasked with enforcing these cases is a defensive position, meaning it is very busy defending against Kristen's lawsuits, Nick's lawsuits, and when they bring enforcement actions, that's when they have time to. And even 2 years ago, they made very clear that they could maybe bring 2 Animal Welfare Act enforcement cases a year. And now, of course, they've got a lot more on their docket to defend. Staffing has been vastly cut. And then last thing you might be wondering is, but I heard Bondi and Rollins announce they're prioritizing this enforcement. And the problem there is that they are myopically focused on criminal enforcement. And the criminal enforcement mechanisms for the Animal Welfare Act are extremely limited. It's also just a lot harder to prove up a criminal violation.
Yeah, absolutely. Just a little follow-up, Delcy, on what you were just talking about, that the agency indicated that they could maybe bring a couple of enforcement actions a year. If you were to just ballpark, how many enforcement actions approximately would you say they would be justified in bringing based on animal welfare inspection records?
Dozens. The warnings are in the bad cases. It's not like they're just giving out warnings for like nothing violations. Those nothing's happening. And that's the vast majority of them. The warnings are what we're seeing when animals are dying, when animals are suffering, when animals are injured. So dozens. I said there were what, 73, 78 just for research facilities. That's not even counting the other types. So It's a lot. We need a division or a section within DOJ that is actually committed to this and resourced to do it.
Yeah, absolutely. Okay, let's get to some of our wonderful audience questions. This one comes from Christy Fox. Hi, Christy. Given the court's deference to agencies to carry out their responsibilities as they see fit, what options are there, if any, to challenge the USDA's choice not to issue fines?
So,
Elsie,
I guess
that's probably for you. Yeah.
yes. And hi, Christy. I love seeing multiple former students on the webinar. So this lets me talk about my favorite footnote. So the issue here is actually a much older Supreme Court case, and that is Heckler v. Cheney. And there, the Supreme Court held that you can't challenge an agency's exercise of enforcement discretion under the Administrative Procedure Act. And Footnote 4 does carve out a maybe little possible window. I've not had success with it so far, but they say what we don't have here. So they're distinguishing a case where an agency erroneously believes it lacks jurisdiction, where it has, quote, consciously and expressly adopted a general policy so extreme as to amount to an abdication of its statutory responsibilities. This might be that. I would argue that it is in the context of research facilities, but in the context of not regulating birds at all for decades under the Animal Welfare Act, that was not sufficient. So I'm leery of our ability to challenge enforcement, exercise of enforcement discretion, unfortunately.
Okay, another wonderful question from our audience. For anyone, now post Chevron, are there cases where courts are being forced to, I guess, interpret scientific or empirical data to determine what is the best interpretation of a statute? And maybe a follow-up to that, why is that a bad thing?
Nick, you want to go?
I'll make mine really quick, and yours will probably have more substance. But I would just say, I mean, I feel like the extent to which courts and judges do that, get into the weeds on the science, for example, or the technical literature that informs an agency's decision, really has largely always been a question of just judicial temperament and kind of will. I mean, that's, my take, right? I can't prove that. I think a lot of judges would, in a Chevron world still do the same thing. I mean, that's how we're going to gauge if it's reasonable. It's not just a question of interpretation, but, understanding the context as well. I would say though, I think to the point of the question, I think judges should be doing more of that in a Loper Bright world, to the extent that now those inclined to be like, well, it's a deference case. We don't really have to figure it out. We just kind of have to make sure they're not like, way off in left field. You can't really, you're not, that option really isn't there anymore, right? At least nominally. So it should lead to that. Judges digging more into the weeds. Will it? I'm a little skeptical that it changes much there, but I don't know what Kristen probably has more interesting things to say.
Well, I don't know about that, but I'll jump in. And the question actually was one that Justice Kagan posed in her dissent in Loper Bright, and sort of had this bulleted list of all of these examples of very, very like scientific based questions that were sort of necessary to answer in order to interpret statutory phrases, and gave an example from the Endangered Species Act, and specifically what constitutes a distinct population segment, which is in the definition of a species in the ESA. And she pointed to an example involving the Western gray squirrel, and like, how is a judge supposed to know what squirrel population is distinct from another by looking at a dictionary? Like, it's not something that judges are usually equipped to do, as was highlighted all too well in a decision issued, I can't remember if it was before or after Loper Bright, but where Gorsuch mixed up in the context of a Clean Air Act case and smog, he confused nitrogen oxides or NOx with nitrous oxide, which is laughing gas, 5 times. So, and I think that's one of the reasons why the Loper Bright decision was generally seen as scary, because you're now handing these scientific questions over to judges, and in some instances, given the nature of some of the questions of statutory interpretation that arise, particularly in the some of the statutes that we deal with that are science heavy. I don't know if that's totally answering the question as opposed to an anecdote, but
No, I think that's great. Another question to throw out to everyone: if we look back 10 years from now, which of these decisions do we think is most likely to have had the biggest impact on the regulatory state, and why, for anyone?
I'll weigh in. I think it's too soon to know. I think we're still very much seeing how this plays out. There are 2 cases. The Supreme Court just heard a case about the Seventh Amendment jury trial right, and then they just granted cert on another one. So a lot of this is going to be getting fleshed out in the years to come.
And I would just briefly add, I mean, I agree. It's too soon to answer that question on those terms. I like the question, but if I had to bet, or like just kind of how do I think about it now? It's this sort of synergistic kind of, these cases build on each other, some in pretty obvious ways. Loper Bright and Corner Post, for example, others in less obvious ways. But we're going to get, a decision as well this term on basically, the slaughter case, where Humphrey's executor, and the idea really of okay, what's left of independent agencies, and to what extent are any kind of tenure protections allowed constitutionally. If that goes the way I unfortunately think it might, independent agencies, they're already being hacked away, right? They've been hacked away and hacked away. But the idea of professional, with some independence, actors within the executive branch that are kind of subject matter experts, and independent agencies, all, having that independence. I mean, that's a big factor too. Like, now it becomes all the more beholden to really the president, right? And so that could be the biggest of all, depending upon what happens over the next 10 years. But it's a big multiplier probably for all of these cases too.
Yeah, absolutely. Another one for everyone. Do we think that Congress is institutionally capable of drafting the level of detail the court now seems to require? And could this potentially offer advocacy organizations more opportunities to craft policy through lobbying?
Well, one thing I'll jump in here on that I forgot to say in talking about Loper Bright is that the court did point to some examples of statutes where the relevant statutory provisions give agencies sufficient discretion to act within the sphere, and it pointed to phrases like, enact regulations as appropriate or as reasonable, and pointed to the Clean Air Act and the Clean Water Act as some examples of statutes that have that language. So perhaps Congress doesn't need to be that specific if it has those terms in the relevant laws, recognizing, of course, that they can't go too far without then violating the non-delegation doctrine, which is a whole nother thing we don't have time to get into. But no, I don't think Congress is capable of anything really right now except horribleness. So but hopefully that will change.
Yeah. Kristen, another question to you. Might we see a softening on Loper-Bright from conservatives given the current executive's encouragement of novel readings of statutes by agencies? What do you think about that?
I think that's a really interesting question. I mean, I think, again, it's kind of too early to know. I mean, the decision was touted immediately by Trump and Musk as, supporting their deregulatory agenda, and Trump issued an EO to agencies to, identify regs that they could get rid of in light of the decision. But, another doctrine that conservatives in particular have been latching onto is the major questions doctrine, and the notion that if something is like so important and implicates a significant economic cost, that it's not necessarily something that an agency is tasked to handle, like climate change or student loan forgiveness, for example. And I've seen some folks question whether that doctrine would have been needed in light of Loper-Bright. And so I could see conservatives sort of embracing Loper-Bright as sort of supplanting the major questions doctrine. So maybe not, but who knows?
Okay, this will probably be our last question. And this one, I would love to hear from everyone if everyone has thoughts. Based on what we know about the Supreme Court justices through their writings and public statements, what administrative doctrines do we think might be on the chopping block next? Who wants to predict the future?
Go ahead.
Oh, I mean, I was sort of just going to repeat some things that I've already said. So Nick mentioned the removal case, the slaughter case that's pending before the Supreme Court. I think that's a big one right now, viability of independent agencies. I also do think, to Kristen's earlier point, I think non-delegation is going to come back. They don't have the votes that they need yet, but there are some people who really, really want to take away delegation to agencies.
And sorry, go Nick.
No. You go ahead, Kristen.
Okay. Really quickly, there is I think it's scheduled, or argument is scheduled for October of this year anyways, but, and that has to do with, what constitutes a final agency action, at least with respect to, the Department of Army or the Air Force, whatever that department is, and they submitting a permit application under RCRA, and whether that is a final agency action that can be challenged, and whether it triggers review under NEPA. And while the question is pretty narrow and tied to a RCRA permit application, I'm worried, given the court is who it is right now, that they could erode at what constitutes a final agency action, which could make it even harder for advocates to get into court, because under the Administrative Procedure Act, you have to challenge a final agency action or a failure to act. So it's scary, and one we'll be watching closely.
Great, thank you. Nick, we do have time for you to weigh in.
Okay, I think I've got my point. I just scratched out. So I think that one thing that I also think at some point is going to be addressed squarely, or more squarely, by the Supreme Court is, what basically the role of vacatur, vacating, setting aside, right, a rule, as sort of the historically kind of the default, like, well, yeah, that's what you do when you find a regulation is unlawful, versus, I don't have the empirical data to really say it's a growing trend, but it seems to maybe be. There's certainly more discussion about it. I feel like it's popping up in more places, versus, observing there are problems with this regulation, right? Procedural or substantive. And nevertheless, we're going to remand, right, to the agency to cure these. And in the meantime, we're keeping the rule in place. And that latter practice to me should really, I think, be the exception to the rule. It should be used sparingly, and I think we could see some movement on that one way or another. And if the Supreme Court, weighs in there in a clear, forceful way, that's pretty darn important as well.
Okay, we will end there. Thank you so much